In this video, I wanted to discuss bail. What is it? What's the process through which bail is acquired? Are there any conditions on it? How is it posted? So on and so forth. Bail is what is set in a criminal case when you're charged with a crime to ensure that you end up showing up for court. It can be in the form of cash or a bond, and you're not always entitled to it. There are certain instances where you're not going to be entitled to receive bail, and the court can commit someone to the custody of a sheriff without having bail set. So your attorney that represents you should know when that's going to occur. And sometimes it can happen if you've been charged with a violation of probation as well. But essentially, there's going to be a pattern when bail is set in any local criminal court or county courts with respect to what the bail amounts are going to be depending on the level of the crime and what is involved. You can make an application for bail when you've been charged with a crime, and your attorney goes about that by acquiring evidence and presenting evidence to the court for things like your reputation, your character, your habits, if you're employed, if you've lived in the community for a long time, if you have family present, if you have a prior criminal record, if you have any issues with respect to responding previously for other charges, if it's a very serious crime and the evidence against you is very strong, or you're seeking bail on an appeal and the situation is such that the appeal doesn't look like it's going to be successful. If there's also a likelihood that the defendant would flee, that's another situation that the court's going to take into consideration. What are the conditions that can be imposed if you want to have bail put in place? There can be an order of protection put in place. If you commit another felony while you're released on bail, that bail can be forfeited. You can be required to surrender your passport. You can be required by the court to remain within the jurisdiction of the court. You can be required to periodically report to the police or probation. You can be required to attend drug and alcohol counseling as a condition of your bail. You could also be required to surrender your driver's license. There are also instances where the court can conduct what is called a bail source hearing. A bail source hearing is essentially a situation where the court thinks that the person who is presenting the bail is not the rightful owner of the proceeds that they are, the money that they are putting up for the bail, or the court has reasonable cause to believe that the money that's being put up for bail is the proceeds of a crime. You find that in drug cases. There's also a situation where a defense attorney can make an application to have bail reduced or changed. That's if there's some sort of change in circumstance. Somebody in the family is gravely ill, somebody's on their deathbed, something like that. Your family's going to be evicted, the house has fallen into foreclosure, things of that nature. Your attorney does have a mechanism through which they can make an application to the court to ask if bail is going to be reduced. That's a situation where your attorneys can make an application to the court and possibly get it reduced on behalf of one individual. Most of the time, when there is a significant bail set, you're going to end up having someone in your family contact a bail bondsman, and any attorney that does criminal defense work is going to have a bail bondsman that's available, and they'll be able to put your family in touch with the bail bondsman so that that bond can be taken care of. So if you have any further questions about this, please feel free to pick up the phone and give us a call, and we'll be happy to talk to you about it in further detail.